Okay, good afternoon, everyone. You're welcome to the first debates, moots, and mock bootcamp. You're welcome. It's my pleasure to have all of us here, and I just want you to fasten your seatbelt. It's going to be a beautiful ride for these 3 days of this bootcamp. So you're all welcome. Very quickly, we'll get into the introductions. So about the foundation, Honorable Justice Innocent Umezulike Foundation is an international non-governmental organization that was formed to honor the legacy of Honorable Justice Innocent Azubike Umezulike, OFR, FCIRB, FIIAN, who at the time of his death was an acclaimed professor of land and property law. He authored over 25 books and served as the Chief Judge of Enugu State, clinching the longest serving Chief Judge in southern Nigeria. So the foundation delivers its mission through the promotion of excellent legal education, research, and charity initiatives. Some of our facilities and programs include the Law Library, Legal Research Center, annual lectures, workshops, seminars, educational grants, and funding. Now, the HJIUF Moot, Mock, and Debate Bootcamp. The Honorable Justice Innocent Umezulike Foundation Inaugural Moot, Mock, and Debate Bootcamp is an intensive program that is designed to cultivate the next generation of advocates and orators. So this bootcamp serves as a beacon of opportunity and learning, aiming to foster critical thinking, articulate expression, and persuasive communication skills among students from diverse academic backgrounds. Throughout this journey, facilitated by seasoned mentors and experts in the field, you will find a unique platform to not just enhance your skill, but also to forge connections with like-minded peers who share a passion for debate and advocacy. So the HJIUF Moot, Mock, and Debate Bootcamp signifies more than just a training program. It represents a commitment to excellence and a dedication to empowering the youth with the tools and techniques necessary to excel in the acts of persuasion and communication. As you embark on this transformative journey, envision yourself not only as a proficient debater, but also as an articulate voice capable of shaping dialogues and effecting change in your community. Approach each session with an open mind, actively participate in the discussions, and embrace the interactive learning experience. This collaborative journey of discovery and growth holds immense potential for each of you. So once again, I welcome you all to the HJIUF Moot, Mock, and Debate Bootcamp, where the seeds of advocacy and oratory are sown for a brighter future. So for today, for the sessions, I'll just give a little rundown of how it will go. We're going to have 2 sessions today. We're going to have the session on mastering persuasion, argumentation and logic, constructing sound arguments, and logical reasoning. So for the second session of today's bootcamp on case/debate topic analysis, research, and writing, we have Ugochukwu Obed with us. You're welcome. You're welcome. It's good to have you here. Okay, so Ugochukwu is a dispute attorney at Babalakin & Co., where he works chiefly on dispute resolution matters. He routinely researches and advises on wide areas of domestic and international laws and practice. As a reformative global policy enthusiast, he's building expertise in jurisprudence, taxation, and international economic law. He's the convener of Dear Trial Enthusiast, a platform where he shares trial tips and strategies with lawyers within and outside Nigeria. He has mentored over 400 Nigerian law students and young lawyers, especially as relates dispute resolution. He was recently decorated with an award as 30 under 30 Rising Star in the legal profession and was a nominee for the Best Young Litigator for the year 2023. He's a member and fellow of renowned professional bodies such as Society for Advanced Legal Studies, Young Institute for Transnational Arbitration, Young International Council for Commercial Arbitration, Young African Leadership Initiative, Young Singapore International Center, Associate, Chartered Institute of Arbitration, the Nigerian Bar Association. So with a virtual ovation, I want us to welcome our second facilitator for this bootcamp, Ugochukwu Obed, as he takes us on his session on case topic analysis, research, and writing. You're welcome, Ugochukwu. It's good to have you here. You're welcome.
Yeah, thank you very much. Ruth, thanks for having me. And it's quite an opportunity to share with everyone case debate topic analysis. So add legal research and as well as legal writing, or research and then writing. These are actually very, very important areas. If we're being sincere with ourselves, given the age and time that we found ourselves, particularly as it borders on writing, right? So writing back in the day could have been like a skill on the side where, because of the word of advocacy, people get to gesticulate and people get to adumbrate, they speak to different issues, and then there was a lot of praise, high praise there on oratory prowess. But in this fourth industrial revolution, we are beginning to see how things are taking a new shape. And if you're not able to be a master of the art in terms of good writing skills as a mode of communication, effective communication, then you will be like lost in the post. So yes, that's why I feel like this particular topic is indeed very crucial, because if you miss it, then they are good that we have different opportunities whereby there are webinars and all trying to teach the same thing. But then how about you just like get the point now, so that next time you are now working towards personal development on how to get better, because it can only get better really so long as you have your hands wrapped around some of the defined principles. Now, there's when you hear the word case analysis, or okay, because I can't share my slide, I'd like broken it down to what we're going to consider. We're going to consider the scope of case/debate topic analysis. Then, when you hear that word, what comes to mind is, okay, you want to first, if you get case analysis, you want to know how to analyze a case. But then that's pretty much saying the same thing, just that you are placing one word ahead of the other. So you want to analyze a case means that first thing you need to understand what is required in that case. So when you are dealing with a case, the first thing is that there's already a factual issue or a factual background. So you want to, okay, what is there in the fact? That's the very first thing. So it is broken into three layers. You have the first layer being to examine the problem, and then you have the second layer being to work out the alternative solutions, and then the last one being to propose an effective solution. So that's pretty much what you want to do in a case analysis, and the same thing you want to do when you're dealing with debate topic analysis. You want to know how to examine the problem, what you might want to call issue, not necessarily a problem, right? So something is thrown at you, a case. Let's work with the case first, and then they've given you a factual background concerning a breach of an agreement, and then so you are looking at the fact first to say, okay, fine. X said that he entered into a promise, or there was a promise from Y to X. You want to know what is the nature of the promise. Okay, then you keep reading further, and then you say that Y gifted X a vehicle, and X did not furnish a consideration. So these are the facts that are revealed to you So you are watching closely first to know, okay, and then maybe in the course of, or rather, there was a promise to gift a car without a consideration, and then X is now coming to you as a lawyer or as an advisor that you should please, what are my remedies? What are the remedies available to me, given that he promised me, even though I did not furnish a consideration, but he promised me that he was going to give me a car on XYZ date, and then he did not. So that is the fact. We're not even trying to delve into what are the legal implications. We're just dealing with the facts. So you have to understand the fact, you have to understand what is required of you first, because there are too many principles, there are too many concepts that are always hanging on the air, but you have to know where to rest them on, and that's the fact. So the fact is very, very key to anything we're doing. Say you're doing debate topic analysis. The debate is all men should cook. You say all men should cook. The should is having that compulsory or that mandatory tone. Should. So you are required to do something. All men being the subject class, and then cooking being the object class, and then you're like wondering, okay, fine. Where is this coming from? Why is it said that all men should cook? You want to understand, okay, fine. What is the art of cooking itself, and why is it that important? So you are trying to analyze just from the topic itself. You want to understand the topic, because it's once it's just like, you know what, all men should cook, and then everybody start arguing, but then you've not even examined it itself to understand what are the possible issues that could arise if on the subject of cooking as an art. And why is it that we've had, from the historical perspective, why is it that we've had more women cooking than men? And why is it that there's not a need for men to cook? Just you examining before you start going for that, to the fact that, okay, fine, perhaps there's a proposition that cooking is just a life skill, and it's very important that everybody knows how to, right? So this is just trying to get out of the way. Now, so if you're able to, back to the issue of as to the promise tree, the entire promise thing, what if you're able to examine it first? The next best thing is to look at, okay, what are the alternative solutions? What can I bring together? So let's say it was on a paper form. You've put there your facts, your factual background, or your background facts. That is where you are showing your understanding of the facts that were told to you by, let's say, a client in quote. Now, you put your understanding in paper form or in written form, so that it even helps you understand what the key facts are. Now, when you understand the key facts, your job is like 50% done. You understand what is required of you. You know that the person wants your advice on a particular or a supposed breach of a promise. Now, the next thing will not be this. You now apply it. Okay. So, what are solutions that are available to this person who claims to, be wronged by somebody's breach of promise? And then you're not looking at it. Well, the law says that if you breach a particular promise, if there's no consideration furnished, then there's no contract. If there's no contract, then you cannot claim breach of contract. And breach of promise is usually tied to things like maybe a promise as to marriage, which is under the Evidence Act. But then if that's not the case here, so your mind is trying to walk through possible solutions and blockages, and then you're not saying, okay, fine, it could have been different perhaps if the promise was one that was under a deed of gift. So if it was a deed of gift, then perhaps she will have a day in court, or X will have a day in court. So it's just walking through those very fine elements. So when you walk through effective, alternative solution routes, it now takes you to one particular thing, being what will not be your final solution. The solution that, having walked through a stream of strategies or a stream of loops, you are able to come to say, okay, fine, I think from all things considered, this is the best thing available to this particular person. Now, we're saying person, it could not only be a person, it could be for a particular idea or for a particular concept. This is my best argument on a particular point. So the argument is, or let's say the issue, and as we're flowing now, the issue of breach of promise. And then you're saying, well, breach of promise should not exist as a matter of consequence in terms of exposure to liability if there is no deed of gift, for example. Now, that's your conclusion. But before you walk through the conclusion, you had to walk through the fact that, okay, fine, let me consider it. What is really at stake here as to fact? Is there any fact that could vary so that could incorporate issues as to deed of gift? Was that contemplated? If that was contemplated or not, well, this could have been the position if there was a deed of gift. So it sort of makes so that's why I said the very first thing is to have an understanding of what is before you ask the fact. Now, let's take it a step further. when you seek from the examination of problems to win your solution line, ask yourself what are the alternatives and what can be forgone. Now, a brainstorm of the alternatives first embraces one's depth in logical reasoning. So now you see that, like I said, it is 50% of the job when you're able to, come to that point where you say you have an understanding of the factual circumstances or perhaps what that topic is really about. You're hearing things about, let's say, same sex, or you're hearing things about a proposition saying men who rape women should be sentenced to death. Now that's the proposition, right? So you have to understand. Okay, fine. Why is that said? Why is that thought out there, right? So you're looking at, okay, what's the gravity of the offense? So you're looking at a couple of things to come and say, okay, fine, you know what, I'm going to be anti the death sentence, or rather, I'll prefer that because of the issue of an eye for an eye, they should make it the person should have spent an eternity in cell or in prison, right? So that's like two sides of the coin. One is saying life imprisonment, the other is saying death penalty. But then both of them actually had a full understanding of what was at stake. It's just that they've preferred that because of the gravity, they see the gravity as attracting a different consequence, right? So now let's look at how to, because all this is now flowing into, because when we're just discussing things about effective solution lines, you also have to bear in mind that there will be a lot of research process or thought process that would have gone into all of these things, and as very practical as possible, right? You may have stumbled on, you might be able to put them to practice. You might try, but you might struggle. But then I think there's really an easy way around some of these things. You just have to apply yourself to it. Now, for you to know how to deal with, let's say, you have a proposition or there's an argument on the table or an issue that needs to be cracked. You want to ask yourself, okay, fine. What research method can I adopt? Research/writing method can I adopt that will make for an easy flow in terms of how I want to structure my argument and how I want to deliver it. Now, some of you might be aware of what they call the whirly bird approach. Yeah, so the whirly is WHIRLYBIRD. That's a bird. So a whirly bird approach. And this is very important for both research and then for writing. And I say so because the whirly bird approach is structured into 4 key areas. And the very first area is identified as the madman phase or the madman stage. And after the madman stage, the next area is what we call the architect stage. Then after the architect stage, the next point is the carpenter stage. Then after the carpenter stage, we have the judge stage. Now, I'm going to try to be as practical as possible. So let's walk back again to the issue on, let's say the scenario that I was trying to give on the issue of breach of promise. Now, on the issue of the breach of promise, when you are told those set of facts, what you want to do is your mind is working as to so you could take like a note with a pen and then you start writing, and this is the madman stage. You're writing things that are connected to that particular factual issue. So you have things like, well, from the facts available to me, there's a promise from Y to X, promise Y to X, and then you're saying, so promise or promising relationship. You want to now look out for, okay, and then you're saying that promise X or Y did not give X a particular item. okay, even after promise. So breach.
You know, last year in the competition, I think though it dealt more in the area of cross-examination, but it actually showed that some persons did not really get the crux of the case. Being able to know what is expected of you when a scenario is painted, it's very key. Knowing the type of arguments to make, it's very crucial. That's knowing the crux of the matter at hand would help you structure your arguments better. Okay, Ugochukwu, you can continue. You're welcome back.
Thank you. I don't know, network carried me away, or I was surprised when I just left the meeting.
Yeah, understand that.
Okay. Okay, so I was trying to walk around the madman stage. So I'll do that a bit quickly. Now, so the thing is, I was saying, so what comes to mind if you're looking at, okay, breach of promise, you're looking at what are the consequences, what are the principles really in terms of, and when they say there's an agreement between two people, what makes for an agreement? So you're noting down what makes for an agreement between X and Y. When can it be said that there's an agreement? So then you're gonna say, so what are the elements that I should be looking out for? So usually you might say that you've filled up this paper with just ideas running around your head as to what this thing is really about. Take it to something like a bit, debatable. You want to say all So I was saying, okay, let's even try to use like something like a debate topic now. We're saying, let us say something straightforward. So always give me a debate topic that comes to mind.
I have suggestions. Let me not mistakenly give out one of our debate topics. Let's give suggestions. Students.
Okay, any suggestion, please.
Okay, phones should be banned in secondary school.
Thank you very much. So
is that
phones,
a debate topic? Anyway.
Phones, let's not try to work around that. Phones should be banned in sex schools. Okay, good. So what the madman fees will be looking at is this. So if there's phone, and then there should be banned in sex schools. So you're looking at three things. So the very first thing that is very easy to take out is the should. The should is mandatory. It's saying, okay, fine, it's compulsory that, I mean, you are trying to say prohibit phones from, from sex schools. You're not looking at one thing. Why are they saying prohibit this subject, and why are they saying from this object they should not have the subject? So you're thinking, okay, so what is the relevance or importance of phones? And then you start listening at a good number of it that comes to your mind first at first blush, and then you're looking at, okay, secondary schools. What is it about secondary schools? What do they do in secondary schools? What is it? What do they do in secondary school? It's a place where students have to go through a great deal of learning, and they are looking at the fact that, okay, fine, would it have been easier to get rid of phones from secondary school in the first industrial revolution? You think, well, there were not exactly a lot of phones then, so it was like a question of getting rid of them. It was just not operable. Then you look at the second revolution, third revolution, they want to look at, okay, when the phone starts coming into play, and what are the merits and demerits of phones, generally speaking. Now, those in the secondary school, do they meet the statutory requirement age of 21 years? And is it a statutory requirement that for you to have a phone, then you must be a particular age? So you're having a lot of questions popping through your mind at the madman phase. You've not placed your thoughts together yet, but your mind is all over the place. So I hope you guys can hear me.
Yes, we can.
I hear you very clearly, sir.
Okay, thank you. Okay, thank you. So your mind is all over the place. You're trying to appreciate the concept, because if you do not appreciate the concept, you can't go head on one-on-one with another person who has appreciated the concept. Because in trying to appreciate the concept, you are looking at the loopholes, to the concept. You're looking at ways to advance the concept as to your understanding. Then, so you're looking at a great deal of everything. Nothing can be left untouched. So that is why you have to appreciate the concept, because without appreciating the concept, it's going to be very slim, or it's going to be a very slim chance for you to, advance very logical arguments when you've not even had an opportunity to think through it in the very first place. Now, so this is what the madman does. So the madman has done the very first heavy lifting by going through a lot of things and scribbling them down without even making sense of it yet. Fine. Then the next best thing is the architect's face. Now, you know what the architect does? That designs and then just trying to put an outline to things. So he says, you know what? I've seen how your mind is working on this debate topic given by one of us here, which is all phones should be banned in sex schools. And you say, you know what? I'm going to outline it. And outline it now, what do? You don't draw a few lines there. And then you're saying, in one heading, you're saying meaning of, maybe you can say meaning of schools. You put out definitions of by well-established authors and all of that. Then you're looking at another heading again, and you're saying, okay, meaning of schools, meaning of phones, and all of those things. And then you're looking at another header is saying, what are the advantages of phones? What are the disadvantages of phones? What are the advantages of schooling? And is there any demerit? You're pointing out all of those things. What are the things that could really lead to peer pressures in school? What are the level of exposures of students in schools in current times, and what were the usual vices that were accustomed to students in secondary schools prior to this industrial revolution. So this is going to take a great deal of research, but you have to have it out there in your outline because you're trying to structure things. And then you are looking at things like, okay, fine, if I have thought about this, then you're looking at, okay, fine, what does the law? Is there any existing legal framework or regulatory framework concerning this particular area in terms of, schools, students in schools, handling devices or gadgets, right? What's the risk mechanism? Is it the case that the person who's the proposition saying that phones should be disallowed in secondary school, does that proposition have at the back of his mind the fact that more than one phone could be a problem, or is it an outright, prohibition, of phones to students in secondary schools? So this is not how your mind is working. Just you want to have some kind of clarity, and then you are doing this because sometimes you are going to be the one being the proponent, and then sometimes you're going to be the one being the opponent, and then so you want to understand, if I'm going to switch from the angle of being, because you have to be your own devil's advocate. If you're going to play devil's advocate and you want to be the opponent of a view that you felt, if I was to be the proponent, it's going to be easy. What could have been, the possible ground that you could come from? Is it a topic that could have two sides to it, right? So that's why you have to have things in proper outline. So you're looking at what are the weaknesses to students having a phone, what are the pros and the cons, basically. So you have all of these things structured out there in written form, and then with all this outline, you're able to do a further study on things that you've outlined. And in doing further study of things that you've outlined, you'll see the reason to either take out some of the things that you've outlined as being less probable, or you're probably not the outline because you have seen that, okay, fine, in terms of my further studies, I've seen that there are even more concepts that I could have ever thought of. So you're improving your outline on that note. So the thing about this well-liberated approach is that it's so connected with legal writing, and I say so because I'm going into that right now. So we're seeing our legal research. So you are doing your research now, and I mean there are a lot of research toolkits. I don't know if I should mention all of that now, but if I should at all. But I mean, when you have an outline, you know what you are going to research on or research for. It that depends on the kind of topic. Is it a legal topic? If it is a legal topic, you have to make recourse to legal text. Library preferably. I like to think of the library, there are a lot of books there, so you can always make recourse to substantive law if it's on a legal issue. If it's on a philosophical issue or an existential issue, I mean, some of those things you may have to look at, also through the lens of other people's views, right? Like say, for example, the existential issue that can it be said that a human can be allowed the opportunity of eating another human being on extreme measures or circumstances, like what happened in the principle in R versus Dudley and Stevens, where they ate the person who was the weakest because they were all hungry. So you're looking at, okay, fine, that's really delving into a great deal of morality, and the thing about morality is that right and wrong is quite relative, right? So if you're going to be faced with, and that's those things get a lot interesting because it's right or wrong and it's being relative. So you are right, I'm right, we are both right, and it's fine. So it doesn't depend on who's able to advance a very superior logic, and that's what I like about debate and Moot activities is who can advance a superior logic. Can we just keep? Okay, but I was just trying to make a point on the outline basically, and then it takes us to the next phase, which is what I call the carpenter stage. Now, you know what the carpenter does? He just like he hits nails into holes and all. So it's about time we have our first draft. Pretty much, let's have our first draft, right? So in having a first draft, you are looking at legal writing, pretty much legal writing. Don't get so excited. So some people could get a lot excited because you've done a great deal of research and you're like, okay, fine, let's have point out like libation on the floor, and then you get a lot excited, and then you are in your own head. So there's this idiom that says that don't be hearing your voice only, right? So if you keep talking to hear your own voice, you won't be able to be attentive as to when how people are frowning as to your level of your expression, your tone, your communication skills. It could be very poor, but because of you are so excited and full of yourself, you're writing in high sounding words. You are remembering all your legal jargon and you want to pour all of it down there so that you can impress, I think, yourself. So you have to be very careful in that regard. So what you want to do in the capital stage is to flowing from what the madman has done as to the heavy lifting and what the architect has done as to the outline and what you have taken, the step you have taken in terms of going out there to do for that research or study. You want to now put down your first draft. So in your first draft, you have to take notes of certain things. It's very, very good, and it's advisable that your issue is thrown out to everyone's face. Let everybody know what you're trying to say in a nutshell, in a summary, right? So summarize what you want to say, the entire point you want to make. Summarize it first. So, for example, I could just use a case scenario. So, in a case scenario, someone is saying that this court lacks jurisdiction. Please excuse me. I'm trying to delve into this scenario. This scenario might seem a bit too. It's quite litigious, but then I also just make a point out of it. And then someone files what we call a preliminary objection, right? We're just trying to challenge the court's jurisdiction. So in trying to challenge the court's jurisdiction, what the person does is to challenge it on several grounds. And I'm just going to start with. I will just go to note 2 grounds because it's a lot, and then that's not the entire point of what we are discussing right now, right? So let us deal with 2 grounds that were captured in this notice of preliminary objection of this particular party. One is that the court should not proceed to hearing this matter because the mode of commencing the action is defective. The party prescribes that the court ought to have entertained this suit if my client had filed the action under originating summons, but since my client had filed it under a writ of summons, then it's fundamentally defective. That was an argument. And then 2, he said a lot of things, but I'm just going to dwell on 2 because of time as well. So 2, it says, well, let's deal with, say mode of service. So he's saying that we have not complied with pre-action protocol or something along that line. So let us leave those 2. But if I'm supposed to respond to that thing, there's a very hackneyed or there's a very boring process that you find many litigators run through in them because of that is what they have as a template. So you see things like counter affidavit and written address in response to notice of perennial objection. To say introduction. It's so cliche. It's so cliche. And then the next thing, I think the next is background facts. The next thing, issues for determination. They answer the issues, and I say argument on issues. Issue one. So the thing is, you want. Yeah, you get it. So that's what they do. So what's how we advise, and what I want to admonish us to do here is look at it from a different standpoint. Imagine you do this. You say, in discussing or in addressing the grounds of objection raised by the applicant, the respondent would address it on the following issues, summarized as follows. Then you start doing your summary at the very beginning. Then you start, number one, it will be incorrect in law for the applicant to hold that this. This is because that. In simple English, you're not trying to abuse anybody, because you used to see some people writing saying that it is very stupid for him to argue this. To be it's not a fight. Don't make your point simple, concise. It's always that thing that the person misconstrued, he misapplied, you see all the miss. I'm like, come on, only one of those things could have made the point. If you want to say misconstrued the law, it's fine, but misconstrued, misapplied, yeah, come on, just pick a struggle, say one thing, move on, say one, move on, make your point. So guys, bear in mind, what I'm saying is this: if you want to, for a very better or an improved way of writing, let us know your thought process from at first blush. So summarize what you want to say in the entire lengthy paragraph. If it must be lengthy, your work must not be lengthy. Straight to the point, right? The truth is that some people believe that the more they write, the chance they have to persuade the judge. But the truth is that they are not being realistic. In reality, a judge has a trunkload of cases in his docket. Why do you think the judge wants to settle down to read your brief? What's so special about your brief? What is so special about your brief? You say, okay, I want to read this one line by line. No. If you can summarize your entire gist at the first or second page of your work, he reads and gets a sense of where you are going. It makes it easier for him to follow you. If he's not convinced as to how you have put together your thought process, but because of the way you are writing with brevity and precision, he might say, okay, let me even see, even though I'm not too convinced on that point, let me see how you may have argued it and what authorities did he cite that I may be persuaded by. Also, you get so precision, right? Precise. Don't be all over the place, right? So what the capital is doing at this juncture is having the first draft ready, starting first with making you guys see the key summary of what he wants to say, going further to delve into the issues. Now, do not bore readers or bore your audience with too many details, except where they're extremely important. For example, you're not doing things like, okay, I want to work with that debate topic again. All phones should be in sex schools, right? It should be banned, right? So let's work with that. The United States saying, history will have it that on 21st March 1992 at King James Palace Road. Now, when you start doing a lot of dates and venues, one thing is going to happen for sure. Your audience will begin to narrow their attention to your date and time. They want to be sure that they do not lose what you are saying on those particular historical events, rather than seeing the main gist, which is the substantive or the meritorious part of your argument, which according to you might even be the juicy part. But because you want us to label so much on too many details as to date, event, and as far as I'm concerned, unnecessary information, you will lose the audience. Especially when you now put your main gist in the middle of your work. So if people are struggling to keep up with the number of historical dates and events, then they will lose interest when they get to the middle, because they think everything is just about all of that. So you have to be careful. If it's not so important, you can say history had it that straight to the point, and then you're not like, take us back to the issue as soon as possible. Stay on the issue for as long as possible, and then if you must digress, then digress a bit as to, but that digression should also matter in the grand scheme of things. You get? So you may be like, rather than saying history will have it that secondary schools have never been having phones. No, history will have it that on XYZ date, 2000 and this, as very number this, one Cardoso, I said that to avoid all of those narratives that are actually like boring, you may just want to say, over the years, it's been established that phones, students in secondary schools are not encouraged to use phones. The reason is quite simple, or the reason was quite simple. You're using words because, I mean, that's not the new narrative now, according to, because it could swing both ways. And then you're just stating the reason why. And then you're going for that to say again now. That, bear in mind, that was at the first industrial revolution. And when we look closely at what was the philosophical thought that was running at the time, was it the age of reason? Was it the age of technology? Was it the age of science? You get. And then you start in 1952, to be precise, what was
So we are still at the judge stage. I hope we are noting this down in our writing, so that someone will not send essay in Moot courts competition this year. Okay, you're welcome, Ugo. You can continue. So you can start dropping your questions now. You can start dropping your questions now. Hope we are noting this point. So your brief is going to be part of, in fact, I'm actually thinking that after Ugochukwu has taken his time to really do a good job on this brief writing thing, that we may slightly increase the points allotted to briefs this year in our Moot court competition. So please, knowing how to write is very, very important as a lawyer. Your first page should be as captivating as possible, that someone will be encouraged to look at the next and all. It's just the same way with talking in your speech. The first 1 minute, 2 minutes, it's very important. You can either gain your audience attention or you lose it in that first or second minute of speaking. You need to bring in your very best at that initial phase. So if you have questions, this is actually the time for questions. This is the 4 stages that he noted. I think the last one that he's going to deal with is the judges phase. You now thinking through what you've arranged and written. If you were to, that's after writing something, ask yourself, if you were to evaluate what you have written, how would you? Try to be objective. I know it's your work. It's actually very difficult to be maybe objective if it's something that is yours, but it's very key in bringing out really, really compelling arguments. Ugochukwu, you're welcome. You can just talk about the last phase. You're muted. Okay, you can continue. It's actually time now to give them room to ask
questions. True.
Round off the
true time. So let me just quickly just wrap it up, right? So there's the last phase, and then the last phase is what I call the judge phase. So when you're able to have together your written work, that's the very first draft. The judge phase is just saying, how about you review your work? So
exactly,
it's not nice that you put together a very lengthy period of time in doing brain work, research work, and then you put out a draft that has a lot of typos, or your syntax is not right. So the judge is saying, let's do a peer review. You can do it yourself, having a time off to relax and come back to it, or you can do it and not be satisfied, run it by a third party. Please look at this. Does it read well? Because when you write, it has to be things that are speakable. Don't just write and say with high sounding words and then people struggle to, you're even struggling to pronounce the word that you have put in your paper. It's not, you're not impressing anyone when you do that. So it has to flow. So check for flow, check for everything, and then that work is ready to go. So with that, I would say thank you very much, because I've taken some time off. So thank you very much for having me. I hope it's been very clear what I've said so far. Thank you very much, Ruth. Over to you.
So much, Obed. You've been so brilliant. Thank you. I'm so glad I made a choice. We made a choice of you as the person to handle this. You've really done justice to this. And we look forward to tomorrow, Obed will take us on cross-examination and rebuttal tactics. Fasten your seatbelt is going to be very interesting. You know, last year I was unimpressed. Truth be told, I was unimpressed with the cross-examination question.
We can't hear you, man.
You can't hear me? Is everyone facing the same challenge? Anyway, we'll get into that.
No, man.
No,
okay.
I can hear you loud and clear.
All right. So tomorrow he's going to handle cross-examination and rebuttal tactics. We're going to have him again tomorrow. So there's a question here. Ugo, I don't know if you can see it. As regards legal research, what would you recommend the law student?
Okay, I can see. They said, as regards legal research, what would you recommend law students to engage in to be better at it? Is it physical training, mentorship by what is this?
Legal research.
Legal researchers, attending boot camps, expatiate on that. Oh, well, to Abdulaziz's question, I would say there are textbooks that you could read. I will share some with Ruth straight away. Yeah, I have books that you can read on legal research and writing. Very beautiful books, very beautiful books. So, and then if you do physical training, I mean, if there's that opportunity to do physical training, then that's fine. But yeah, I would say spend some time reading textbooks that talk very well about legal writing. And then another thing again, they say practice makes perfect. So the more you see how things are written, in practical formats to how things should work, and you try to, like actualize them when you're putting together your draft of memorials, so it gets better when you're getting reviews from people who, from judges or assessors who tell you, oh, fine, this work could be written better. You're writing in first pronoun instead of third pronoun, for example. You're writing in passive voice instead of active voice. You want to know what's active, what's passive voice. You want to just know how to get better. So the more you do it, and the more you study from some textbooks, also attending sessions, the more you just get better, right? So yeah, I think you can have a great mix of all of it together, so long as you know what you're doing. So you won't have conflicting ideologies of writers and things. To live in a bad place. But find your voice. Important thing. Yeah.
Okay. So for the textbooks and the slide, that's why we wanted you to register. We needed you to register. We are going to, for those that we have their emails, you will get it in your email after this session. So any other question? Please ask your question now on analysis, case analysis, research and writing. Ask. Okay. Thank you, Favor, for what you sent. So any other question? Okay, no other question for today. All right, you can keep sending your appreciation. There is something that happens when someone finishes a session and then you appreciate the person. The person is encouraged to do more. He took out time from his schedule, both him and the other facilitator, Daniel Oladoja. These are busy people to have this. This is something they are doing of their own free will, and it's like an investment. So the least you can do is appreciate them. Let them know. One thing about anytime I attend a conference or a meeting or a training that I gain value from, when I'm reaching out to the speaker or appreciating the speaker publicly, I don't do a generic something. I am specific. Thank you for sharing this. I learned this. I personally have some career relationships that came just because of this. Not necessarily that. It opened the door to learn more from the person. So Daniel Oladoja has taught us today on persuasive, mastering persuasion, and then Obed has also taught us on case analysis, research, and writing, and they really did so well. So let's appreciate them. But I think one of the major forms, or that one of the highest appreciation you can have for a facilitator or an organizer of a program is putting that thing into practice. I look forward to having that a different debate. Last year during the debate competition, it was more like, I know in debate you will cram. That's just the truth. You would cram some things, you will cram your points and all that, but you don't need to let the audience know that you crammed it. It was so mechanical. A lot of persons just come and say, well, I want to oppose it. It was just joke. There was no. Anyway, Daniel will talk about it tomorrow in public speaking. Your voice texture, your modulations. There are times where you should maybe use the pause effect. Even in muting, in court, there are some times where you're making a part. Yes, I know that a lot of litigation now, the bulk of the work is done on paper, but there are times where you will need to address the courts. Now, at that time, how you would present your points, that's thinking on your feet, your mannerisms, the words you choose to use, it is very, very important. And that's why we're having these trainings. Tomorrow, Obed will be taking us on cross-examination and rebuttal tactics. Last year, I said earlier, I did not finish that, but I'm going to finish it now. Last year, I was saying that the cross-examination by a lot of teams, unfortunately, was nothing to write home about. Like cross-examination that should have yes or no answer, as in close-ended questions. A lot of people, we are talking plenty. That's how you ask the question. You've said so much that the question is so open-ended that the person that is responding to it now has time to tell a lot of stories, and it kills the essence of the question. Anyway, I don't want to say much. Tomorrow, I know Obed would finish that topic, as in that's butcher it, because it's his area. Thank you so much. Thank you so much for your time today. Thank you so much for bringing your best foot forward in doing justice to this topic. I appreciate you. We appreciate you. Thank you. Thank you. So I don't know if anyone, okay, you want to say something? Okay.
No, I was saying thank you very much for having me. It's always a pleasure. And I look forward to tomorrow as well. Tomorrow, I'll be here to discuss cross-examination. I'm looking forward to it. I'm all pumped. Yeah.
Yes,
thank you very much.
I'm really looking forward to it, because that's actually one of your area.
Yes, my baby.
Our upcoming SAN. All right. Yeah. So thank you so much, every one of us, for being part of today's session. Mama, is your hand raised?
Yes.
Okay. Yeah, quickly.
Okay, as regards case analysis, is IRAC also an important way to analyze cases?
Oh, yes, it is.
Okay, thank you.
Yeah.
I think he talked about it when he was starting. IRAC he might not have called it IRAC, but issue rule, that's being able to know what's the issue. Then what are the rules that applied? I know he talked about it. That's what's legal framework is there. I think when he used the example of I've forgotten the example he used, Z-RIP or something like that. Okay, what's the legal framework about it? So when you know the law, you would now know how to apply which aspect of the law. There are laws, and then they have exceptions. Sometimes it could be the exception that would apply in that case. Sometimes it could be the general rule. But if you're coming under the general rule, you should be sure that the thing is airtight, that it defeats, that it is none of the exceptions, that it did not get caught by any of the exceptions. Yeah, I think that's the word. Okay, then that's the application now, then the conclusion. So he did not specifically mention Iraq, but I think his points actually highlighted Iraq. You keep using Iraq for as long as you have anything to do with the law. It would keep coming up. Okay, even in debate itself, yeah. It's just that in debates you might not have rules, but okay, what's the issue? What are the arguments in support of the issue? Maybe in debates now you could bring in you could bring in your arguments is about, it might not be laws now. In debates it's more open-ended. It could be a law in support of that. It could be emotion. I think Daniel talked about it. By emotion I mean maybe incidences or history, not like not now tell us story, but let's say something that's been prevalent in a community. You could use fact and figures. That's the rule now if it's in debate, right? If it's in a debate, you could use, okay, by reason of, see what the law has said, that's if bringing law is necessary. But you could also bring in the fact that, okay, there has been a prevalence of this. See statistics that has showed this. These are the rules that you can apply to that debate topic. That's in the side that you want to be ruled in your favor. Do you get? Then after showing the statistics in support, or the statistics or rule or stories or incidences in support of that point you're trying to make, you now apply it to that debate topic that you're given, then conclude. I look forward to initiatives, mind-blowing initiatives taken by debaters this year. You can even try, we are going to see if our final round would be a physical debate competition, but that would be based on a number of factors. But let's see how it goes. We may have the final round as a physical debate competition, but being able to use different communication styles. You could start with questions, just like Daniel said. You could start with sarcasm on your opponent's point, or you could even preempt what they would say. But one thing with preempting what your opponent would say is be very sure of that point you're trying to make, so that you won't end up shooting yourself in the face. Okay, I think we'll call it a wrap for today on mastering persuasion and case analysis. See you tomorrow as we learn about public speaking and cross-examination tactics. Thank you, Ugo. Thank you to everyone that joined us today.
Thank you. I'm signing out. Yeah,
All
bye.
right. Bye.